Welcome to The Explainer. Today, we are talking about a massive Supreme Court decision that completely changed civil rights law in America. And the crazy part? It all came down to the meaning of a single word, written way back in 1964. You know, it might sound wild, but before 2020, the answer to that question was, well, it depends. For literally millions of Americans, whether you could be legally fired for being gay or transgender depended entirely on what state you happened to live in. It was a confusing, inconsistent legal mess. And these are the three people whose stories forced this question all the way to the Supreme Court. You had Gerald Bostock, a child welfare advocate, who was fired after his bosses found out he joined a gay softball league. Donald Zarda, a skydiving instructor, was fired right after he mentioned he was gay. And Amy Stevens, a funeral director, was let go just after she told her employer she was transgender and planned to live and work as a woman. So what you had was this situation where the lower courts just couldn't agree. This meant your rights could literally change just by crossing a state line. It was this legal patchwork where LGBTQ+ workers in one part of the country had federal protection, while folks just a few miles away had none at all. It was clear the Supreme Court had to step in and make a final call. Okay, so it all boils down to this one simple phrase, because of sex. This was written into law as part of the Civil Rights Act of 1964. The huge question the court had to answer was, does discriminating against someone for their sexual orientation or gender identity count as discriminating because of sex? All right, let's get into the decision itself. The final vote was 6-3, which was a landmark ruling. But what really shocked people was who wrote the opinion for the majority, and the very specific, almost mechanical logic he used to get there. So the opinion was written by Justice Neil Gorsuch, a conservative judge, and he used a legal philosophy called textualism. Now this is what makes the case so fascinating. Textualism means you ignore what lawmakers might have been thinking or intending way back when. You just focus with laser-like precision on the literal meaning of the words on the page. And the big surprise here was seeing this typically conservative method lead to a massive expansion of civil rights. This is the key. It's called the but-for test, and it's this really simple but incredibly powerful piece of logic. The court said you can't discriminate against someone for being gay or transgender without also taking their sex into account. Think about it. If an employer fires a man for being attracted to men, but they wouldn't fire a woman for being attracted to men, then the man's sex is the but-for reason he was fired, and according to the plain text of the law, that's illegal. And this quote just perfectly captures the whole textualist argument. The majority flat out said, look, Congress in 1964 almost certainly wasn't thinking about LGBTQ+ rights, but they argued that just doesn't matter. The court's job isn't to be a mind reader, it's to apply the words on the page exactly as they're written. Now let's flip over to the dissenters, because this seemingly straightforward logic set off a huge, fundamental debate among the justices about what the Supreme Court's job even is. What you're seeing here are two totally different philosophies on how to be a judge. The majority said, we just follow the literal, logical path of the words. But the dissent said, no, we have to look at what those words meant to everyday people back in 1964. It's this core debate. Is the court supposed to be a strict textual interpreter or more of a historian? The dissenters came out swinging. They argued that the majority wasn't just interpreting the law, they were basically rewriting it. They said, look, if you want to add these new protections to Title VII, that's a job for Congress. That's what the democratic process is for, not something for unelected judges to decide on their own. And this metaphor from Justice Alito's dissent really cuts right to the heart of it. He accused the majority of just pretending to be textualist. He said it was like a pirate ship flying a false flag, hijacking the law to get to a result that fit with modern values, not with what the statute actually said. So once this decision came down, the impact was felt almost right away, and the ripples started spreading far beyond just employment law. Lower courts immediately started grabbing the Supreme Court's but-for logic and applying it to other federal laws that also ban discrimination because of sex. Yeah, this ruling set a huge new legal precedent. All of a sudden, you saw federal courts using it to expand protections in housing, to make sure transgender patients were treated equally in healthcare, and then, probably most controversially, to tackle discrimination claims in education under Title IX. But, and this is a really big but, this ripple effect has not been a clean sweep. The application of this logic is being fiercely fought over, especially in the world of school sports. Right now, federal courts are completely split, giving us conflicting rulings on whether Title IX means schools must allow transgender athletes to compete based on their gender identity. So while the Bostock decision settled one really important question about employment, it basically blew the doors wide open for a bunch of new legal and political fights that are still raging across the country today. And this is probably the single biggest unanswered question that Bostock left behind. Justice Gorsuch, in his opinion, actually made a point of saying that the court was not deciding how these new protections would square with the First Amendment's guarantee of religious freedom. This leaves some massive legal questions just hanging in the air. You've got laws like the Religious Freedom Restoration Act and special rules for religious employers that could create exceptions to Title VII. So now the courts are stuck with this incredibly difficult job of figuring out where one fundamental right ends and another one begins. And it's no surprise that this legal uncertainty is mirrored in our politics. You have some who have tried to narrow Bostock's reach by defining sex as strictly binary. And on the other side, you have those who see the decision as a landmark victory and are pushing to apply its logic as broadly as possible across every federal law. And finally, with all the legal theory and the political fighting, it is so important to remember the people who got this whole thing started. Gerald Bostock did eventually settle his case. But tragically, both Donald Zarda and Amy Stevens passed away before the Supreme Court could rule in their favor. Their fight, though, created a legacy that changed the law for millions of people. In the end, the Bostock case really leaves us with this huge, fundamental question about our whole system of government. As our culture changes, as our language evolves, who gets to decide how old laws apply to new realities? Should it be the courts, or should that power belong only to the people we elect? It's a question that really gets to the very heart of the American legal system.